take a break from me real fast, and y'all have driver's license or IDs on you?
I ain't gonna submit to no ID. Listen, you call the clinic right now. Listen, I ain't got time for this. Don't worry. I don't mean to be rude or nothing.
Okay, no, you do need to give me your ID or driver's license.
Alabama law fits in a scheme of laws that were passed decades ago throughout the country called stop and identify laws. These laws were discussed by the U.S. Supreme Court in Hybel v. 6th Judicial District. And they made clear two things. One, the Fourth Amendment is a limit on governmental authority on what officers can do. And this court said they can ask people to identify themselves in the context of a Terry search. But they said state law establishes the citizens' obligations. Now, in Nevada, that statute had been interpreted to only require a person to provide their name. Now, here, this statute doesn't need any interpretation.
Isn't this a reasonable mistake, though? Let's just say that on the part of the officer.
Well, that's what I want to talk about. Is it a reasonable mistake applying the law? The only issue that a plaintiff believes there's any question about factually or really legally is this section 15530, which says what a citizen's obligations are under Alabama law. It says an officer, if he has reasonable suspicion, may demand of him his name, address, and an explanation of his actions.
Well, that's a correct statement of the law, but the question is, was it reasonable for an officer in Officer McCabe's position to think that he was refusing to provide his name when he said he wasn't going to provide ID?
So if this statute was ambiguous and says something like the citizen has to identify himself, then maybe an officer might think, oh, identify gives me the option of demanding a driver's license. But Alabama law says it in letter. May demand of his name, his address, an explanation of his actions. The statute is not ambiguous.
So you say you don't need a case, you're just relying on the statute itself.
Correct.
And so he couldn't ask for his driver's license. So, I mean, that's the clearly established law, period.
Correct.
Let me ask you something. Do you agree that the police officers were mistaken on the law here? I mean, it is clear. You agreed it is clear.
I will respond to that question this way, Judge. This is not an obvious clarity case. This court has to determine whether the law is clear in light of existing precedent. There is no existing precedent defining the contours of 15-530.
He says he doesn't need it because he's got a clear statute. The statute is clear.
I respectfully disagree. I think that reasonable people could disagree whether or not you have to only use those magic words that Mr. Sherrod says.
A reasonable officer trained to be a police officer ought to know that you can conduct a Terry stop and ask someone for their name and identifying information, but you can't stop somebody on the street and just ask them for their driver's license unless it's for your safety because they've been driving a car.
If I'm focusing on 15-530, the statute that essentially codifies Terry, and it says that an officer may demand name, address, and explanation of actions, there's no case out there that I'm aware, Alabama Supreme Court case or otherwise, that says thou shalt only use those words and only those words. And to the extent you deviate from it, you have violated clearly established law.
Trained City of Hoover police officer reasonably ought to know that you can't stop someone on the street and ask them for their driver's license. You're saying that an officer can make that mistake. The critical word is reasonable, right?
I would agree that it needs to be a reasonable mistake, yes, sir. But again, I think that the vast majority of officers out there conducting Terry stops are not going up there and saying, sir, may I have your name, address, and will you explain your actions? I think that they're going to say, can I see some identification? That is a reasonable request of a police officer. I would even add, ID is broad enough to include one's name, or at least a reasonable police officer could think so.
There's no issue with the officer asking for ID. That's not against the rules. Officers do ask for ID on the street of pedestrians all the time. The question is, does it violate Alabama law for the person not to provide it? The Hybel court said they could ask for ID. They just couldn't arrest him under Nevada law merely for failing to provide that.
What are y'all doing?
I'm for second description. Huh?
What are y'all doing?
Get in the car.
36,
Is this your car?
3-3 drive off tag.
One of my customers.
1867.
One of your customers?
No, tell. Yeah. I was over here earlier.
Whose car is that?
That's mine.
The black one?
Yeah.
We also premise the arrest on the basis of 3269. 3269 is likewise not clear by its terms, and case law makes it even less clear. 3269 is a statute that says it makes it a crime for a driver to provide a driver's license upon demand by a police officer. Under Alabama law, the term driver is not limited to one who is driving. It is also based upon someone who is in actual physical control of a vehicle. That is where the legal fuzziness comes in.
Could a reasonable officer think that here, Mr. Edger was the driver of the vehicle?
A reasonable officer could wonder if he had been a driver of a vehicle. Almost everybody walking around in this country had to, at one point.
If that's the case, then wouldn't there be arguable probable cause?
No, because the statute specifically said if you were driving. He was not driving. The wheel was off the car he was working on. The other car was shut down. He was a mechanic working on a car.
Mr. Edger wasn't the driver of the car. This wasn't his car. He wasn't the driver. He explained it to the officer. He explained that to the officer. Does the Fourth Amendment permit an officer to demand that he show his driver's license?
I think an officer could reasonably conclude that you could. I think that could be a reasonable mistake. But I cannot point the court to any law that says you can or cannot. I'm not arguing that he was a driver of the car that was on the jack.
Again, statutes that set forth citizens' obligations by the state legislatures, when they're clear, officers don't get to disregard what they say and say it was a mistake. This is simple. He was not driving.
What if he's not driving, but he's reasonably able to drive?
There could be scenarios, and there's lots of Alabama case law talking about somebody that's effectively in control of a vehicle, like people trying to get out of DUIs who are actually sitting there in their car with the keys in it. I mean, there are all kinds of scenarios where you get close to the line, but this is not close to any of the lines in the statute or in the law interpreting that statute. This is not almost driving or nearly driving. This is a guy who's working on a disabled car. The car's shut. The car's not on. Nobody is driving. The vehicles are parked.
I'm arguing that he was in actual physical control of the vehicle that he arrived in. When Officer McCabe arrived, she said, "Whose car is that?" And he admitted, "That's mine." And it was just feet away. When we're talking about can reasonable mistakes be made, I would urge the court to take a look at how ambiguous the law is surrounding what is someone who's in actual physical control. It speaks in terms of the power and ability to operate, move, park, or direct whatever use or non-use is to be made of the motor vehicle. And that can be based upon the totality of the circumstances. And this court in Cantu also recognized that the officer doesn't have to see them driving. That black car was feet away from him.
The officer wouldn't have any reason to know. Maybe the other person there was the driver.
Correct. But, either one of them, they were potentially drivers, future drivers, past drivers. They were not currently driving, and no reasonable officer could believe they were driving.
The district court's opinion was the undisputed body camera footage makes clear that Officer McCabe didn't ask Edger for his name and Edger didn't refuse to explain his actions. However, a reasonable but mistaken officer could have believed that Edger's failure to provide his driver license violated Alabama Code Section 15-5-30. The 11th Circuit Court reversed qualified immunity. The Alabama statute is clear. It lists only 3 things that the police may ask. This is not an issue of magic words that must be uttered. There is a difference between asking for a specific information, for example, what is your name, or where do you live, and demanding a physical license or ID. The information contained in a driver license goes beyond the information required to be revealed under 15-5-30. Further, neither the parties nor our own research can identify any Alabama law that generally requires the public to carry physical identification, much less an Alabama law requiring them to produce it upon demand of a police officer. There simply is no state law foundation for Officer McCabe's demand that Mr. Edger produce physical identification. It was thus clearly established at the time of Mr. Edger's arrest that she could not demand he produce physical identification. And because Officer McCabe's demand for an ID or a driver license went beyond what the statute and state law required of Mr. Edger, she violated clearly established law.